What is a 70-30 divorce settlement? 70-30 refers to one of the separated parties receiving 70% and the other party receiving 30% of the property pool. Property includes all the assets and liabilities of the parties to the relationship. So what is a property settlement versus a divorce? If you're not divorced or unsure on what to do about a divorce, we have covered off on this in a video that you can check out on our YouTube channel, where we have heaps of great educational content. A property settlement is the splitting of assets and liabilities between a married or de facto couple who are separating. A divorce is the legal ending of a marriage. The only relationship between the two is that you need to have finalised your property settlement within 12 months of your divorce certificate being issued by the court. Otherwise, you need permission or leave of the court to divide your property. Permission is not easily obtained on the basis that the court presumes you have to have resolved your property division during this period of time. Your online property settlement suggests you should sort out your property settlement first and then your divorce to avoid any time limit problems. So, is a 70-30 split common? Not really, but it is a common question. Every property settlement depends on its own circumstances, and there are no specific splits, be it 50-50, 70-30, or something else. To make consent orders, when determining a matter at final hearing, the court will go through a process to calculate the split. To work out if a variation from a 50-50 split is needed, the following 4 steps are considered. The first step is to look at all assets and financial resources involved in the property settlement. This is everything the parties currently own, even assets or debt acquired before the relationship, and those assets bought after separation by either party, although these may be treated differently because of who contributed to them. The house, the car, cash, stocks, any household furniture, superannuation. Debt can include a car or personal loan, credit cards, and even a HEX debt. Assets and debt are included at the value at the date of a court hearing or the date of agreement being reached, rather than at the date of separation. This is because the value could change very quickly and it may be unfair to use a much earlier value. The second important step is assessing the contributions made by each party towards the total property pool. These contributions include financial and non-financial contributions. One party may have had significant savings or a home at the time cohabitation commenced. Where one party gave up a career to have the children, this would be an indirect or non-financial contribution. Consideration must go towards the contribution of each party at the start, during, and after the relationship. It is generally not a dollar-for-dollar exercise, and financial contributions may well be equally offset by the other party, having a greater care component for the children. The third step is assessing what is commonly called future needs, and reviews the ability of each party to support themselves moving forward. Important factors considered for each party include age and state of health. It can also include income earning capacity. If one party has the primary care of young children after separation and has a lower income earning capacity, an adjustment of the property in their favour is likely due to these factors. The fourth and final step is to look at whether an outcome from the above 3 stages is fair and whether any other factors must be considered. The property pool size is a genuine consideration here, and also how the assets will be split is important. As an example, if one party retains the former matrimonial home, which is an asset capable of being sold, versus the other party retaining mostly superannuation, which may not be accessible for many years, then there is an imbalance in how the value of each can be used. In our experience, it is quite rare for a final adjustment to be made for fairness factors, and the issue of contributions and future needs is more heavily considered or weighted. Let's look at a case study. Emma and Jason married at an early age and separated after 15 years together. They had 4 children, and at this time the children were between 4 and 10 years of age. Emma was a nurse and could work part-time following separation, as she had the predominant share of care for the 4 children. Jason was a carpenter and worked full-time. Although Jason paid child support, the value of the asset pool of both parties was quite small, so the court awarded a much larger share to Emma to allow for the expensive care for the 4 children and the fact that she could only work part-time. A 70-30 division took into account these factors. This is where your online property settlement can help. Resolving your property settlement helps you move on with your life and plan for the future. Reaching a fair agreement between you and your separated spouse is important. If you need some assistance, then your online property settlement can assist in arranging a mediation with a highly qualified mediator who will help achieve a new solution. Once an agreement is reached before or after mediation, then your online property settlement can document that agreement and save you thousands of dollars by doing it online from the safety and comfort of your home. If you would like to know a little bit more on this topic, you can go to our website and check out a blog on this exact same topic. We also have heaps of other great educational content on there. So head to our website, propertysettlementonline.com.au. Best wishes from the team at your online property settlement.